start. At the outset, it would be apposite to mention here that it is not in dispute that Tulsiram had received in partition amongst his brother certain properties in the year 1960-61, and the present suit properties were purchased by him in the year 1962 and Wide sold it in the year 1994. He had transferred the same in the name of his son-in-law and daughter. It has been the claim of the plaintiffs that their predecessor Harishchandra, who was in service, has also contributed for the same, and owing to harassment by his father had committed suicide. Non, Nonetheless, the alignment in favor of defendant number 2 and 3 was not sustainable, since Tulsiram did not have exclusive right to sell the property, and this has been the content of the original defendants, that these properties were self-acquired properties of Tulsiram, and the consideration that he had received by selling the properties which he received in partition was spent on his medical treatment and the marriage of his daughters. The Learned Counsel for the original defendant number 2 and 3 has contended in the written submission that the witness of the plaintiffs Lakshman has admitted about the hospitalization of Tulsiram for about 6 months after partition, and this admission has been termed as golden admission that supports the contention of the original defendants that Tulsiram spent entire amount towards hospital expenses and was proved beyond reasonable doubt. However, this admission has not been taken into consideration. Assuming for the sake of argument that this admission was made by the witness and ought to be accepted on its face value, even then, by no stretch of imagination, it can be said that whatever amount Tulsiram had received from the sale of properties received in partition was spent in his treatment. Moreover, in the absence of any cogent evidence to show that after recovery Tulsiram had any other source of income from which he had purchased the suit properties, it could not have been observed that suit properties were self-acquired properties of Tulsiram. The theory propagated by the original defendant number 2 and 3 that the fact of hospitalization of Tulsiram automatically tantamounted to corroboration of the fact that the entire amount was spent by him cannot at all be accepted. Furthermore, much stress has been laid on the admission of another witness of the plaintiff Lakshman, wherein he has admitted that after the partition in the year 1960, Tulsiram had sold the land that fell in his share and went to reside at Silli, and at that time Harishchandra was 10 to 12 years of age. He has been contended that if that was the case, the finding recorded by the learned judge of the trial court that Harishchandra also contributed to purchase the land at Silli is totally unfounded. Nevertheless, even if that theory is not accepted for the moment, but if the suit properties were purchased out of the sale proceeds that Tulsiram received in partition with his brother, then the heirs of the Harishchandra would be certainly entitled to share therein as co-sharer, as has been granted by the learned judge of the trial court, and what has been the contention of the original plaintiffs is that Harishchandra had contributed in repair construction of the suit house. It is also contended in the written submission that Harishchandra was addicted of heavy drinking liquor, and owing to that Tulsiram has disowned him and was residing separately, and after the death of Harishchandra, Tulsiram had allowed the plaintiffs to reside in 3 rooms of the house. In any case, there was no material that could make out that Tulsiram had purchased the suit properties out of his own funds. It is then submitted that the counter claim had not been considered in proper perspective. However, having come to conclusion that the suit property was joint family property, the natural contrary would be the dismissal of the counter claim that claim recovery of possession and other ancillary reliefs. Para. As far as the appeal of the original plaintiffs is concerned, it has been contended that suit being filed during the lifetime of Tulsiram and the plaintiffs, being legal heir of the son of Tulsiram, had claimed one and a half share in the suit property, and that the learned judge of the trial court was not justified in granting 1/5 share. It is also claimed that after the death of original defendant number 1, their share has increased from 50% to 60%. However, since the daughters are equally placed on pedestal of co-purchasers upon the death of Tulsiram, the son Harishchandra and his sisters were rightly granted 1/5 share, and the plaintiffs could claim only the aspect of their predecessor Harishchandra. And considering all these aspects, it cannot be said that grant of 1/5 share to the original plaintiffs along with 1/5 share each to the 4 sisters of Harishchandra is illegal or liable to be disturbed. In such circumstances, application is Exhibit 38 under Order 41 Rule 27 of the Code of Civil Procedure also does not deserve any further consideration. Considering all the opposite circumstances, I do not find any infirmities in the impugned judgment warranting inference in either appeals, and as such I answer the points accordingly and pass the following order. Regular Civil Appeal number 439/2010 stand dismissed.